Welcome, everyone. Thank you for your patience. Thank you, thank you, thank you. And again, hot topics when medical conditions impact the workplace. We've made some changes in 2024, a slight name change as well as a date and time change. And we apologize for the confusion. Felicia and I knew it was changed to 11 o'clock. Unfortunately, no blame or shame, please understand. But to my assistant, overlooked the fact that we changed it to 11 for this particular month and sent the notice out for 1. So we do apologize. And anybody who might miss it because of the change in time, they will receive a recording, as do any registered participants. So again, you will receive a recording within 5 to 7 days. And we do encourage you to share that with your coworkers, your supervisors, etc., even if it's only clips of here and there. So again, welcome. It's already March 13th. It's hard to believe. And already a fourth of our way into the year. And so Felicia, again, thank you for participating with me in this podcast and helping us bring hot topics to the workplace.
Oh, you're welcome. It's my pleasure.
Oh, great, great. And just for everyone, is that Felicia and I do confer at least once, if not twice, before we do this each month, and we talk about what is hot out there. So we're both doing our research regarding EEOC cases, as well as discussing what are some interesting real cases. Not that they're not all real, but just at the local level versus the federal level. To see if we can't use them as learning opportunities. Of course, we always take each case anonymously. And so, can't help it if you may know of the situation. It's not intended to put anybody on the hot seat or anything like that. But again, learning, because there's as I've oftentimes said in these podcasts, and Felicia knows this too, because we both have been in the industry for a comparable amount of time, more years than I care to expect, Felicia, right?
Yes, definitely.
Yeah. And so, we have seen changes, and I've said several times in the last few years that I've seen more changes, more unique kinds of medical conditions, as well as unique accommodations in the workplace than I ever did in all the years ahead of that. So just to let you know, things are always changing. That's why it's always important to live, learn, and grow and get better at our practices. So today, let's start off with highlighting a few things. And we've sort of fallen into a pattern, I guess. We like to address what are some hot issues that the Equal Employment Opportunity Commission, or EEOC, the federal agency that oversees the Americans with Disabilities Act, what have they dealt with? What have they, what kind of decisions have they emerged with? And so we've got a few good ones about what to do and what not to do in that regard. And so, so that's one of the things. And then we'll move into an update on SB 553, Workplace Violence Prevention Plan. And I've asked Felicia to reiterate the 4 areas of concerns, and we'll talk a little bit more about how that's moving along. And then we will move into our last portion of the program, where we will actually talk about, some cases that we see happening out there. And again, some do's and don'ts of how to keep yourself out of trouble and how to get yourself into trouble. How's that?
Yep.
So, welcome again to everybody. So, Felicia, let's get this kicked off. So we can maintain our time frame for about 45 minutes of a discussion. And again, we encourage all of you to, if you have questions along the way, please put them in the chat box so we can answer them, and try to do that real time. So we're dealing with everyone's needs right now. So first of all, when you go overboard, this was a big case involving Coca-Cola and how Coca-Cola actually prevailed in this particular claim made by the employee. So Felicia, I'll let you take it away.
Great. Thank you, Debra. I thought I'd start with what to do, what they did right, and then the other example is what not to do, what they did wrong. So we'll start with the positive example with the EEOC is always good. So this was litigated at the Sixth U.S. Circuit Court of Appeals. And this was a court ruling, but it was a very interesting case, kind of unique. Both of these cases are not work comp claims, but they're very interesting disabilities. And the disability is what matters, and the accommodation piece, not so much whether it arose from a work-related injury or a non-industrial injury. In the first case, EEOC under the ADA allowed Coca-Cola to reassign a driver with Tourette's syndrome to a warehouse because of the employee's use of slurs and profanity that was offending customers. Kind of a unique disability, right? So this particular employee was hired by Coca-Cola, and I want to say this was in Northeast Tennessee. These cases are federal, so they're kind of all over the country. I just like to use them as examples. He was hired and he began delivering Coca-Cola products throughout the county. He was front facing with customers and clients of theirs. And this was considered part of the essential functions of the job, to just talk to clients and deliver the product. In 2006, he began delivering. He already had the Tourette's syndrome, which was progressing. So it was getting worse while he was working. And his Tourette's caused him to use profanity and racial slurs, which obviously was a problem. So customers complained on the route to Coca-Cola about about this particular disability. And then HR started working with him. This is the very important piece on this case. They right away started addressing it, talking to the employee about how to accommodate. He took some time off to get medical treatment for his disability. He requested some FMLA leave, which they granted. Then he requested, his first request for an accommodation was, I'd like to do my job with a partner. I'd like to work with a partner who doesn't have Tourette's, and then he can do the front facing and I can do all of the, off the truck, on the truck, all the delivery and the hard work. Well, Coca-Cola did not feel that that was going to work. And then they met again and they talked about whether or not he could work a route where he didn't come into contact with any customers. Pretty creative, right? Do we have a route like that where you just deliver the product, but you don't interact with anyone? Well, they didn't have a route like that. Everybody was front facing, everybody dealt with customers. It wasn't going to work. So then they met again about what they could do. And then they said, you know what, we can move you to the warehouse because that's not an essential function of that job, that you deal with customers on a front facing level. It's a slight pay cut, but it wasn't very much. And so they did that. They moved him to the warehouse job. So you can see there were many meetings, many discussions about how we could accommodate, what we could do. And he quit after a few weeks of doing the warehouse job and he sued. And what did he sue under? He sued under the ADA for failure to accommodate. And what the EEOC decision said was very interesting in the wording, was that the employer had worked closely and repeatedly with the employee to try to find an accommodation for his disability. And that's where this case hinged. And so they felt that the employer did not fail to accommodate. They did not discriminate against him. And they also said they did terminate him. He quit. And they really kind of bent over backwards, and they showed that in this case. And that is why Coca-Cola prevailed.
Very interesting, very interesting. So this is a good example of where, we had knowledge of a medical condition, but it really didn't surface as a problem until the condition started worsening. And and then that's where you need to start taking a look at, okay, now how is this impacting the essential functions? And of course, as you said, the customer facing is critical. And with that, then, it's important to look at all things effectively. And so, Coca-Cola did do a lot of really good positive things. What would you say is the number one thing that they misstepped on?
Well, I think that there was a little bit of disconnect when he requested FMLA leave. And
Mhm.
they went ahead and authorized that. And then there was some period of time before they started meeting and started coming up with creative solutions to the problem, right? Rather than just saying FMLA leave is your accommodation, go away.
Mhm.
Then they quickly started banding together and started meeting, trying to find another solution rather than leaving it there, because this outcome would have been different probably if they had, right?
Yeah, yeah. Okay, great. So good example. Now let's talk about the beauty company that
Mhm.
didn't do such a good job.
So the beauty company, I want to say this company is in Illinois. They hired an employee with, I'll call it the case uses the term deaf. I will use the term hearing disability. So
Mhm.
that's what I'll use. But EEOC claimed that Voyant Beauty fired this employee on her first day after being hired for their belief that she could not do the job um, working in their, I wasn't a warehouse job. I'm trying to remember what it was, on a production line. That's right. Because they didn't feel that she could do the job because she was deaf. The beauty company, what EEOC cited them for, was said they operated on a quote, unfounded assumption that an
Mhm.
employee could not work in production because of her hearing disability. They did not meet with her. They did not explore accommodation. The beauty company agreed to pay $75,000 in a fine to settle the EEOC allegation that it fired the employee on the first day and that the termination violated the ADA because they fired her even though she was qualified for the job when she interviewed for the job and was hired. And it was shown that she could perform the essential functions because this was discussed in the interview and the
Mhm.
hiring process. And what the EEOC said was that relying on unfounded stereotypes about employees' disability in making employment decisions is illegal,
Mhm.
unquote. And a decision not to hire or fire must be based on a person's actual ability to safely perform the essential functions. So what they were required to do was pay the $75,000 fine. They also, I think, had some back pay. They had to offer to rehire the employee and to train all supervisors and managers on hiring and firing practices under the ADA to prevent something like that from happening in the future.
Right, right. Yeah, that is a key element as far as making assumptions because it does reflect bias and attitude.
Mhm.
And I remember when the ADA first started out, there was a very active program called Windmills that had been developed by EEOC as they call it sensitivity training, but it really was diversity and inclusion type training because we wanted to enhance people's awareness about how they may have unrecognized biases and attitudes towards people. In fact, in those days, it was more of the physical disabilities like the using a wheelchair that you could see, and how could you work, and now we know we deal with a lot more invisible disabilities, and so how we show up and engage and react and respond to our employees when we have knowledge of medical conditions is huge. And I have a situation currently where the employee did her due diligence before we had the interactive process meeting, and so she did raise sensitivity training as an accommodation because of an encounter she had with a coworker and felt that it was very discriminatory and harassing behavior and language. And while I acknowledge that, yes, that's definitely a possibility, and that is something that the employer may consider down the road. However, right now, that doesn't help you do your job. And so it did relate to the incident, so it's a valid concern. But I said, let's stay focused on what we can do to keep you working right now. That can come down later. But it is often times part of the EEOC ruling that employers must engage in the sensitivity training per se. And it's just a good approach to take, because sometimes people just don't know. And as many of you have probably heard me say in an interactive process meeting, until you have a medical condition or you have an employee with a medical condition, many people simply do not know about this whole interactive process and how to provide accommodations. And so there's some do's and don'ts there. So this particular case really does address quite a few things. Yes.
Mhm.
Yeah.
And it's very interesting to contrast what the beauty company did not do in comparison with Coca-Cola. They didn't work with the employee closely. They fired her after one day. They didn't meet with her. They didn't explore any avenues or discuss the disability or ways that they could potentially accommodate, or even if an accommodation was necessary.
Yeah.
So
Yeah.
interesting cases, both of them.
Well, as I oftentimes will say, if you find yourself sort of, jumping to a conclusion, that's probably your first indication you made an assumption and haven't checked in for clarity. And so, yeah, check out those assumptions, get feedback from other people. As you know, Felicia and I remain available, by phone or email, if you have any concerns about these kinds of things, because it's simply too costly to I guess not be a team and not get more information. Yeah,
And I
yeah.
think too, when you're thinking about fit for duty, because Dr. Dupree and I both have a short list, I'd say, of physicians that can do both. They can treat work comp claims, but they can also do fit for duties for non-industrial injuries. When you're thinking about fit for duty, always be thinking about an IPM, because you might not have enough information to really even choose the right specialist for a
Right.
fit for duty. I have a lot of people, or a lot of districts call me, and they want to go right to a fit for duty evaluation to determine whether or not the person can safely work. And a lot of times there's very little information
Mhm.
available. So I kind of think of it now as a two-step process: IPM first, then the fit
Right.
for duty after we get more information.
Yeah, absolutely. And the analogy I would like to give to everybody is, certainly you have a right to do fitness for duty. It comes under the Ed Code, it comes under the ADA, et cetera. And yet, um, without being properly prepared, you're sending an employee off for an evaluation that they don't even know what they're really evaluating. And so, for those of you who brought me in to help with that, you know that I prepare like a referral packet. Here's the issue, here's the condition, here are the challenges we're facing, and here are some questions that we have about, can this person really do the job? And so I've been given feedback that that's extremely helpful. And the only way you're going to know that information is to have the IPM first. I have to admit, I was involved in one where the employer wanted to go right to fitness for duty, and it actually created more confusion, chaos, and unfortunately reduced the trust between the employee and the employer, because the employee didn't quite really understand
Mm.
why they were being sent for this evaluation. And so paving the way, laying the groundwork is definitely something to be considered when we're talking about a fitness for duty.
Yeah.
Yeah. Um, the next one I was going to touch base on are some of the myths and so forth about discrimination and harassment. And I'll start off by saying that, again, just as a primer, so to speak, is that, you know, um, the Civil Rights Act of 1964 is what really addressed our rights and responsibilities, particularly when it came to employment. There are other facets of it too, but employment was the first time it had been really addressed majorly. And so disability is one of the 7 protected classes under the Civil Rights Act. As with many other laws, it took a while for a law to evolve specifically for each one. But this is where, it's illegal to discriminate, harass, or retaliate against somebody who is in one of these protected classes. And I find it's pretty amazing that uh, people simply aren't aware of some of the biases and attitudes they have around medical conditions. And I like to remind people that, you know what, we're all human beings, and you too may have a medical condition that impacts your ability to work. And so how would you want your employer to show up? And so that sort of shifts the mindset a little bit. Um, but what I really wanted to bring out here today was that in doing some research for a newsletter that I've started, uh, you know, it's oftentimes believed that discrimination against people with disabilities is relatively rare in some of these complaints, but in reality, it's quite significant. And so one of the explanations they had for why it doesn't show up so much in some of these published cases is that the EEOC does encourage early resolution
Mhm. Yes.
of the issues, and so that's why they may never rise to a case level like what Felicia has just gone over for the beauty company and Coca-Cola, but it's there. So when they go back to the complaints, not the decisions, we can definitely see, it's pretty high. It's close to 40% of all claims involving discriminatory behavior and attitudes in the workplace. And so that sort of loops us back again to the importance of, take a look at your workplace. Would it be valuable to provide some training to your supervisors, managers, administrators, and things like that? Because this can get complicated, and it is something that we all deserve to have. So with that, Felicia, I want to roll over then into what's happening with SB 553 and the Workplace Violence Prevention Plan that's coming up for July 1st, just around the corner.
Yes, right. Well, we've obviously been having lots of discussions with that with our loss control and safety team
Mhm.
at our work, because OSHA hasn't provided the guidance yet
Mhm.
for the regulations on SB 553, but it comes into play on July 1, 24. We were just moving forward with what we know. What we do know is that all employers have to have a workplace violence prevention plan, and it's going to be required either as part of the IPP, or you could have it as standalone document similar to a lot of your safety documents. And we know that training must be done. So we've been working with our
Mhm.
loss control team on providing some training. It's very school specific, employer site specific. So
Mhm.
it will be different based on your different sites and your different risks, right, at your sites. And then, so the training has to be provided, that's a component, and then a log of workplace violence incidents must be
Mhm.
kept. So these are the pieces, and then now we're just trying to figure out how to put them in play, because we don't have the OSHA regulations yet and guidance from them. So it's a little bit cart before the horse, but the Senate bill is here and it is going to take effect. And so we are working very hard for those of you, that are in the JPA pool on the property and liability side and with the loss control folks to help with all of this. But the four categories of concern that they're really looking at um, is there's four main types of violence, I guess, that they're looking at. And these are the things that you're going to be basically kind of writing this all about. One is type 1, workplace violence by a person who has no business at your work site, who enters your workplace to commit a crime, right? Against either your employees or so this would be a school shooting, right? This would be perfect example of that. Type 2, workplace violence directed at your employees by clients, your customers, your students, your patients, or your visitors, patients healthcare setting, right? Because it's all settings that are involved in this, or visitors to your campus. So violence directed at your employees, but by others that come up that are doing business with your work type, your work
Okay.
site. Type 3, workplace violence against an employee by a present or former employee, supervisor, or manager. So this is a coworker, right, coming into the workplace, or a supervisor or manager or a former employee coming in and shooting up a workplace. That would be that type 3. Type 4 is workplace violence by a person who does not work at your employment, but has and is not one of your employees. So they don't work there, they're not an employee, but they have a personal relationship with one of your employees, or they did have a personal relationship.
Mhm.
And these are the ex-boyfriends and spouses and things like that that can come on to your work site. So those are the four types when they just talk about workplace violence. That's what they're talking about. Those kind of encapsulate all the risks that there are, right?
Right. Right. Yeah, so it's important to keep in mind. And again, that's where your on-site security and protection come into play, et cetera. And so while these four categories exist, again, the guidance does refer to things like bullying, harassment, hostile workplace, so those kinds of things. And so I don't believe, as I was talking to somebody last week, and I mentioned I'm excited about this bill and putting into place because we saw I think the success of the Injury, Illness, and Prevention Plan back in 1993, and that really gave employers an opportunity to look at their practices, and have a good plan. And having been a mediator outside the disability arena, I've mediated many Title VII cases for federal employees that do address, the discrimination, the harassment, the retaliation, and this gets into workplace climate. And if you've read any of my work, I talk a lot about psychological safety. I can't tell you the horrendous cases I've seen because of poor management tactics and strategies, demeaning, diminishing, negating, name calling, beratement, publicly, those kinds of things. And when that kind of climate persists, that's what fosters a hostile workplace environment, and it gets difficult to undo. And it really does affect the culture. It affects employees' well-being. And I've seen many cases of where employees have become so ill as a result of the ongoing poor psychological treatment that they have actually become physically ill. And the only way to help them recover is removing them from the work site. So, we've got a lot of work to do, baby, but we've come a long way and we got a lot of work to do yet. But at least I see this as a start for employers to start taking a look at some of these very important issues. We've come a long way in physical safety, and knock on wood for that. But we still have a lot to do around, those kinds of harassing, hostile behaviors in the workplace. And so, Felicia and I know we have a number of cases that crop up in that arena, and so something very important to take a look at. So, moving on and continuing to grow, and there is training available if anybody is interested in looking at how to bring a program into your site. And I hope to have an on-demand webinar developed in the near future, maybe by the start of the next school year, so that it's something that could be easily accessed, because I know it's hard to bring people together live. So just so you know, I did put a link into the chat box. You can take a look at the full article that was issued by EEOC. A lot of good data, and certainly something to share with your managers and supervisors or administrators if you feel that there might be some issues around how to handle these kinds of cases with a little bit more care, finesse, concern, and compassion. And so it really makes a big difference. So let's go talk about some real cases, what we're actually experiencing locally. And why don't I have you, Felicia, kick that off?
Okay. I'll go ahead and talk about the first case, which was attitude and bias when HR is too close to the situation. So we sometimes see in workers' comp cases where the work comp representative or the HR representative who's responsible for the work comp claims has a work comp claim. So it is one thing I do want to say, some districts cannot do this or don't have the ability to do this, but typically what we feel is best practice is that you move the handling of that file outside of that department, which is a little bit difficult if HR handles workers' comp, but we feel that if the person who handles the work comp at the school district has a work comp claim, they shouldn't be handling it for obvious reasons, and that it probably shouldn't be their supervisor or manager either. It should be somebody else. And so you might think about that, and just in case this actually ever happens, that you kind of have this set up. So this is a real example that'll remain anonymous. So we have an HR technician who filed a work comp psych stress claim alleging harassment from the supervisor and manager in HR and a hostile work environment. The work comp claim was investigated and delayed for more information, and then was ultimately denied pending further information. I think there were medical records and other things that were still being sought. Sometimes in the 90-day investigation period, we don't have the ability to gather up everything that we need. The temporary work restrictions were something that we see a lot with this kind of psych stress claim. No direct contact with the supervisor manager, otherwise capable of full duty work, right? At the district in any department. So the district met with the employee and provided temporary accommodated duty under their return to work program at a site, at a different site, as a registrar. Come forward, and the work restrictions, as the claim progressed, became permanent. And the permanent work restrictions were the same. No direct contact, supervisor, manager, meaning it wasn't going to be resolved. Sometimes these things get resolved in the claim and they kind of work themselves through. This did not. That was the permanent work restriction on the claim. So an IPM was held, and the district went ahead and offered the temporary accommodation as a permanent job, permanent return to work. And I can't remember, Deborah, you'll have to add your comments about pay. Can't remember if it was lateral pay or not. And so it was kind of an unusual situation, and some comments were made after the accommodation. We provided this permanent position, but it had nothing to do with the work comp claim. But it did, right? So in psych stress claims, often what we see as temporary work restrictions and permanent work restrictions. They can't work around a certain student. They can't work in a certain classroom because it may be a trigger, right? That's why these restrictions are in place. It's obvious why the restriction would be against this particular supervisor and manager, because in this particular instance, the statements that were taken on the investigation all reveal that others had witnessed this behavior. So that's a problem, right? And then the comp claim is working through its AOE COE issues, right? On as far as acceptance and where that's at. But it is an interesting case, and I know, Debra, you might want to add some comments to that as well.
Yeah, thank you so much. Yeah. Yeah, we've actually seen this kind of situation in several different claims. And so it is something to be mindful of. And when Felicia talked about, like the if the claim or complaint is against somebody that's overseeing the employee, by not removing it, you really are creating a conflict of interest. Yeah, it's almost like judge, jury, and jailer. Because if you've got already a problem between a supervisor or somebody higher that oversees this employee, then there's likely to be unrecognized or even recognized bias and attitude in how that claim gets handled. And so that doesn't bode well for an employee's recovery. It doesn't build much trust for the employee and the employer to creating a safe situation. And so, again, that goes back to the direct threat. We can't provide the accommodation if it means you're continuing to work, exposes you to risk for harm or injury, or risk or harm or injury to other people. And so those are things to keep in mind. As far as the assignment, again, this is happening in another case I had too, where the employee wanted the other person who they had an adverse encounter a few months back, wanted that person to be removed. And I said, nope, that's not the way it goes. We don't remove students and we don't remove coworkers. You would be the one to move because you've been adversely impacted by it. And we always focus on the employee performing his or her own job duties with minimal to no impact on others around. And we need to try to safeguard that. And so what's happening in that case is that, yes, she has been placed at another location because the doctor again said no direct or indirect contact, so even emails. And yet the physicians had responsibilities to communicate about their respective areas of service. And because of the location of where the employee worked, there was no way to avoid or guarantee chance encounters
Mhm.
because that person would necessarily walk past the employee with the claims work area. And then, too, in emergency situations, there was just no way. And yet the doctor was adamant, no contact. And in this case, it was interesting because the doctor, she's not maximum medical improvement yet. Um, but the doctor did say that while she's in treatment,
Mhm.
no exposure.
Right.
Okay. So we've got a timeline now that we're working with in terms of how long this temporary accommodation might be. And we basically boiled it down to about 4 to 6 months, and we'll reevaluate. Um, what's interesting in this case, we found we found work at an alternative location, but it's not going to carry through the school year. So we're going to have to come back and revisit this in April. But right now she is continuing to work because she said that not working, she was on a leave of absence, not working was not helping her improve. She felt isolated. And she felt it was unfair that she was taken off of work when she felt that disciplinary action should be taken to the other person. So it gets into all kinds of
Mhm.
details that not everything can be, addressed beyond confidentiality, but it presents some unique situations. And I'm going to go back for a second, Felicia, on that particular case and a few others I've had recently, is that again, if somebody's behavior has been identified by an employee as being problematic and causing them stress, et cetera, um, and then let's say we have more people who also feel that same way, then it's like having a big obstacle in the workplace that everybody keeps tripping and falling over. And if that was a physical injury or a physical
Mhm.
obstacle, you'd have OSHA all over you, and that would be taken care of like that. But somehow we seem to treat, some of these psychological issues and literally bad behavior, and don't confront them directly. And so, unfortunately, not much is done for the person who's been the center of several claims, and this has happened in some other cases that I have, entirely different situations. But um, the source of the the source of the injury is still present, alive and well.
Mhm. Right.
So,
You haven't addressed the problem, right?
yeah,
Root
yeah.
cause,
And
I guess.
Yeah, yeah. And so this is again, it's going to be interesting to see SB 553 unfold and how
Mm.
this goes. But I'm still very hopeful that it's going to change the direction for how we effectively manage these things. Yeah, yeah. So I know that one of the things you've already mentioned or commented on, Felicia, is AOE, COE, rising out of and in the course of employment, and today we wanted to attach that to psychological stress. And
Mhm.
so, again, I've got a number of cases like this going on right now. So I'd like to have you kick that off.
So this is another real case that'll remain anonymous that is quite interesting. This is a 58-year-old bus attendant, longtime employee of the school, filed a work comp psych stress claim alleging repeated harassment with the other coworkers in the transportation department that had been happening over a period of time. This wasn't one incident, but there was an incident that culminated that almost came to like physical blows where things were escalating, to your point. And this employee had gone and complained to supervisors and managers and felt that nothing was being done. That was her conclusion there. So the employee had let management know, HR know on multiple occasions that these confrontations were occurring between the employee and coworkers and that there were ongoing racial comments. So that did trigger some investigation and some people looking into things. From the work comp perspective, you know what we do. We go get medical records. We take statements of the employee that was involved, of the bus attendant. We were given the names of all the other coworkers to stigmatize, which we did. And then that's what goes to the doctor to determine AOE COE. And they said no harassment was taking place. What did they say? She's difficult.
Yeah.
She doesn't do, she's difficult to work with and hard to hard to get along with, right? It was her problem, basically. Um, so instead of going to, when you're going to do statements, employer level statements, you want to give people that have knowledge of the whole incident and are not going to just tell one side. So we had the employee statement, and then we had like 6 or 7 of the coworkers, and I'll call them the bullies in this particular scenario, their statements. But there were no statements taken of like management or HR who had a lot of knowledge about what was going on in this situation. And so then the QME exam comes along, which is to determine what's going to happen in the work comp claim. What does the doctor do? Wow, I have this information from this employee. I have all these statements from the employer. This doesn't jive at all. I'm going to defer to the trier of fact on whether or not what good faith personnel actions were done in this case, because I can't tell, right? Kind of like, and we see that a lot in reports with psych because there are different sides to the story. We had what we would call, not a very conclusive result. And that is still going on, but it was denied pending further information, right? More medical records and things that needed to go to the doctor. In the meantime, the employee came and said, well, the district said, how about we move you? Temporary accommodation. We've got some other positions at other sites that we think you would be fantastic for. And the employee said, why should I be moved? I didn't do anything. I like my job. I like working with the kids. There's no reason that I should be moved, to your point. You need to discipline the others. This isn't about, and so then that didn't work, right? There wasn't and then so this person was off work, going through leave, right? That was the accommodation. That's what was happening because the restrictions again were restrictions from the environment, the department, and the coworkers, which make those are very challenging things to accommodate, either temporarily or permanently. And so it was and then obviously the QME said that the person needed further treatment, right? To try to get better, to deal with these issues a little bit better. But the whole case became very complicated, both from what I call the work comp track and what I call the return to work track, which in my head are two different things, right? And very hard for the employer to navigate, right?
Right. Yeah, they can be tricky. They can be difficult. One response I'll share with everyone that I have used that have helped the employee buy into what we need to do is that, given the circumstances, and not to say that we agree or disagree that the other person shouldn't be disciplined, but right now it's a work atmosphere that is not conducive to your health and well-being. And so until we can get things sorted out, it does become imperative to move you to a new location and see how things improve, et cetera, so that we can evaluate whether or not a return to the same location is possible down the road. Because it's almost like, like if a doctor takes somebody off of work because of a stress claim, then the goal is to remove them from work so that they can improve. Well, I've had several cases of where being off work didn't help the person improve. It actually made it worse because they again felt isolated, felt that they were being blamed or at fault, and so this is where change in environment can be critically important, and trying new things out. And we certainly have had people who actually thrived when they had to change environment. They didn't know how bad it was until they had a chance to be someplace else. And I actually had a situation recently. We were trying to go through the accommodation process, and we were doing a little bit extra intervention, shall we say, sort of a mediation approach between some damaged relationships. But the employee finally said, you know what? Given the way things have gone, I'm going to resign. I don't want to continue working here. So, while that was, unfortunate, at the same time, it did solve a lot of problems. And I even acknowledged to her, I said, sometimes people do better if they have a change in environment. But she was already talking about it anyway. I was just trying to say, yeah, that would be supported if that's what you wanted to do. So, it's again, an interesting scenario, right?
Mhm, mhm.
Yeah, yeah. And I want to have you address that last point, and then we'll wrap it up for today. As far as, defending the employer's um, perspective or position over potential violation of employee rights.
Well, I think the one thing from a work comp standpoint, we want to present all the information
Mhm.
um, as as well as we can for the physician to make a decision. It's a
Mhm.
very difficult thing to decide whether or not the overall work-related stress is 51%
Right.
all psych stress, but that's what we ask a QME or a psychologist and a psychiatrist that are doing an AOE evaluation to do. And so what we want to do is we want to present employer witnesses that are unbiased and that can present a clear picture, a fair
Mhm.
picture of what's going on. And then the employee obviously is stating their side. And I think that's very helpful to get to a better medical result and a better medical decision on what's going on. In that particular instance, the medical report wasn't very definitive and wasn't very helpful, honestly, because there was not a clear picture.
Mhm.
It's hard to get a clear picture of what was
Yeah,
happening.
yeah, yeah, yeah. And so, and again, employees have rights and responsibilities. Employers have rights and responsibilities, and this is where, particularly, if a supervisor, administrator is denying or wants to deny a claim, um, it's, I guess, what I think we're both trying to say is it's better to let the process play itself out and do the investigation rather than someone's potentially biased viewpoint about the employee and what's being claimed. Uh, you know, they may not believe it, but the reality is it's true. It's true for the person. And so there was something that I was reading an article the other day where it says perception is reality.
Mhm,
So how I see things is my reality, and how you see things is your reality. But that's where we have to have a conversation, and to help each other understand what our realities look like, our perceptions look like, and take you to the next level. So I would say go back to the facts. What
mhm,
are the facts of the situation? And you may differ on the facts, but at least establish a a structural foundation for the process by, well, what are the known facts? Then we talk about the impact of those facts on people performing. And then, uh, what's important about how we move forward. And again, this is where we take a look at, not only the employee's needs, but also the employer's needs in creating a balanced picture and then creating that forward future plan.
mhm,
So it's FIIF. So just like to share that with everybody. So, a lot of things happening, a lot of nuances. And so again, encourage, this is an area that, you know, uh, the saying, takes a village, right? Well, it
mhm,
takes a village actually to get an employee with a medical condition in the workplace through the process and to ensure safety and well-being and restore people to humanity. Uh, and so for that reason, then I've been shifting some of my work. And so I do produce a newsletter uh, twice a month. And so I've been focusing on more of the return to work, the medical conditions in the workplace kinds of issues, the upcoming SB 553. And just to let other people know, in addition to this podcast, I also facilitate a podcast called Decoding the Conflict Mindset. And some of my upcoming guests will be talking more specifically about situations in the workplace and I even have one guest coming up who was a risk management attorney, and and how she went through her own mental health because of the unbearable workload situation that went on for 3 years. And so I'm excited for that one to come forward. So if you're interested in my newsletter, it's sent out through LinkedIn. But if you are not on LinkedIn, then let me know and I'd be happy to send it to you directly. And so with that, Felicia, any parting words before we wrap up for the day?
No, it was wonderful. It was a pleasure to be with you today.
Yeah, thank you. Thank you everyone for attending. A couple of reminders. We normally do these at 1 o'clock on Wednesdays, and I know we had a lot of people signed up, so that may have been some confusion. We apologize for that. There is a recording that's available that we usually send out within the week after we do this. Again, do share it. We all need to learn and grow from this kind of thing. I have some other new updated forms and procedures. If you visit my website, you'll see what they are. And oh, big news is that my webpage on the interactive process is now available for translation into Spanish, as well as a few other languages. If you go to the upper right corner, you'll see that. And so that will help with our primary Spanish speaking employees. And the video is also now available with Spanish subtitles or captions. So I'm excited to get to that point. I don't know why we didn't get there before, but we are finally. So, but thank you all and have a great rest of the week. We'll see you in April. Okay. Take care.
Be well.